Hey, friends, how are you tonight? Happy True Crime Wednesday. I hope everybody's doing well, and I'm glad that you're all here tonight. I see some familiar faces in the chats. Hi, Sharon. Hi, Julie. Hey, Deborah. And hey, Susie Gay. So good to see you all here. We have a few things to talk about tonight. It's kind of interesting because uh, the big, um, high profile cases that we were all anticipating have all either resolved or are done. And a lot of things have been pushed off until next year. So we don't have a whole lot coming up until January. And so we'll take a look at that. Um, because we just don't have a whole lot on the schedule until January. There are a couple of minor things going on in December, one trial going on in December, but then we have quite a few things coming up in January of 2026. So we'll talk all about those as well. We have a few things to talk about tonight, just updates. And then thanks to Jabberday, who sent me all the documents, we are going to talk about um, the Crumbly appeal. And so we're going to talk about that, and we're going to do a little deep dive. So we're going to get in the weeds. So get out your ghillie suits. And but we're going to start by doing just a few roundups about some cases that we've been following. Before I do that, though, I have some other updates, personal updates to tell you about. Yes, yesterday was my birthday. I'm not sure why 68 seems so much different than 69, but there we are. Um, but the exciting thing for me is that my book proposal for my next book is in the hands of my really able agent, and he is going to start sending it out to publishers, to potential publishers on Tuesday. So I appreciate lots of good juju for that. Those of you who can say a little prayer, I'd appreciate it. So, but it's great, and I am looking forward to being able to share with you um, what the project is. Like I say, after having had my manuscript pirated, and had somebody who harassed my publisher, I really have been hesitant to say too much until things are really cemented. So I appreciate you for all bearing with me while I'm waiting to find out what's going to happen. So that's exciting. Also, we're going to be taking the month of December off, partly because it's the holidays, but also because I'm going to get a new knee on the 2nd of December. And so I'm probably not going to be fit for human consumption for a couple weeks, and then the holidays hit. So just to let everybody know as we're coming in, I cannot believe it's October already, but everybody always says that. Can you believe it's October already? It's crazy, but it is October already. So, um, just to give everybody an idea of what's coming up. Last week, I had several people ask me about some cases, so I wanted to give you updates on those cases based on the requests. So, first of all, I want to talk about Barry Morphew. Barry is accused of murdering his wife, Suzanne. And this is actually Barry's second time being charged with her murder. the first charges were dismissed after the prosecution. Oh, Dawn Shackelford says she's getting her new knee on the 10th of this month. So Dawn, hang in there. And if you have any advice afterwards, let me know. I was really fortunate that my very sweet little next door neighbor had hers done about 6 weeks ago. And so she was a fount of suggestions and information. She gave me several things. She said, you have to get this and you have to get that. So she was really helpful. Back to Barry Morphew, though. The first time Barry Morphew's case was dismissed because of misconduct by the prosecutor, and but it was dismissed without prejudice, which means that they could refile it. So he bonded out again. What someone close to him said is that the funds were provided, supporters of his provided funds through a surety. Now, a surety bond, a surety usually is someone who's going to sign for and it is going to guarantee the bond. And usually that's somebody who has enough assets to be able to assure the bond or is willing to put up their property in support of that. So, as you may remember, Suzanne Morphew disappeared. Supposedly, she was out on a bike ride. She disappeared. Barry Morphew was allegedly out of town on a job site. He worked in construction, and so an early search of the house turned up some kind of unusual things, including a cartridge from a gun used on wildlife to drug them in the dryer. And Suzanne's body was unfound for years and years and years. And then lo and behold, they were out somewhere looking for somebody else and they found her remains as well. The autopsy was ruled a homicide by unspecified means. But in the marrow of her bones, because her body had been out there a long time, it was pretty decomposed. But in the marrow of the bones, they found a drug combination that's usually used to tranquilize wildlife. It was found in her bone marrow, and Barry had a prescription for it to use on wildlife. So, and he had a tranquilizer gun that was for use on wildlife. So, he bonded out a couple of days ago, some earlier on this week, and there is an November 3rd status hearing scheduled to find out the status of the case and to probably set some new dates. I don't believe we're going to get a trial date anytime soon, but we'll probably get discovery deadlines and some of the other dates that are usually set by the court. So the next case is Rawl Valley, Valle. The victim's name is James McGrath. He was a 17-year-old who was stabbed during a house party. You may remember that Rawl Valley has already been to trial once, and they had a hung jury. And so after the hung jury, the plaintiff or the prosecutor, sorry, has now filed some revised charges. So in the first trial, they found him not guilty of first-degree murder. However, they hung on the reckless manslaughter charge reckless endangering, and reckless assault. So now the prosecutor has revised the charges to reckless manslaughter for the death of James McGrath and assault in the first degree for two other people who were stabbed in the fight, and then uh, assault in the second degree for one other person. So those charges were just recently filed, so there aren't any new dates, but we'll keep our eye open to see what's going to happen there. Donna Adelson was denied a new trial. The court denied her motion to interview two of the jurors, and the judge denied her motion for a new trial. Now, one of the grounds that she was requesting a new trial on was the issue which she was saying she had been pressured to make a determination about whether or not she was going to testify, and that she hadn't had sufficient time to consider whether or not she was going to testify. Well, what we found out when the judge issued his order was that there were several sidebars, which we didn't hear, of course, the public didn't hear, but were recorded, where he discussed whether or not she was going to testify. So if you remember, publicly, what we saw was the day that he kept saying, you know, Ms. Adelson, we need your response. Yes, you can have 5 more minutes to talk to your lawyers, but we need you to decide whether or not. And you know, you could be held in contempt if you keep delaying. But what we didn't hear was the next day when they came back into court, the judge called them all back up to the bench, to a sidebar, and told her, you may yeah, I know that your attorney has rested, and I understand that there's that everything is closed, but I am willing to let you reopen your case if you do decide you want to, if you change your mind and decide you want to testify. And she said, well, can I have some time to talk to my lawyer? And he said, yes, you can have 10 minutes. And she asked for 30, and he gave it to her. And then they had yet another sidebar where she came up and said, no, I'm not going to testify. So she had many opportunities to decide and to consider and reconsider. So the judge said, no, no, you weren't pressured into making that decision. And so no new trial. So, and we found out today that she's been moved to her forever home. I am not that familiar with Florida jails, but in a lot of states, they only have one women's jail. There's only one women's jail in Oregon. There's only one women's facility in Idaho. So oftentimes, a lot of women are in the same jail. So not only will she probably be in the same jail with Katie Magbanawa, but she's probably going to be in the same, prison with Sarah Boone and some of the other notorious female inmates in Department of Corrections commitment in Florida. So we will wait to see how she does, but word on the street is that she's not doing very well being in prison, and has had a couple of meltdowns already. The last case that I wanted to bring to your attention before we get into the Crumbly appeal is a case out of Cumberland County, North Carolina. Sorry, I was having trouble reading my own handwriting. And that case is the case of Clint Bunnell, who is the victim, and Shanna Cloud, who is the alleged perpetrator. Clint Bunnell was a 50-year-old retired Green Beret, that's Army Special Forces. He was a medic. He had retired and gone back to school. He was a student at Methodist University and he was working on becoming a physician's assistant. He was in their physician's assistant program. And he disappeared, and a university employee asked for the police to do a welfare check. And the night before, it was revealed that the night before, the afternoon before his disappearance, he had met with a divorce attorney, and he had already informed his wife, Shana Cloud, that he wanted a divorce. He was involved in a relationship with another woman. He was then, so 3 weeks later, a couple of people found a partially dismembered body in a pond. They found the torso, missing all of its limbs and its head. And it turned out to be Clint Bunnell. Shana Cloud was arrested and is in custody without bond. And we are expecting that there is going to be a disposition hearing on November 13th at 9 a.m. Now, I wasn't really sure what in North Carolina they call a disposition hearing. In a lot of states, a disposition hearing would be a sentencing. But in North Carolina, in doing a little research, in North Carolina, the disposition hearing is the time to either enter a guilty plea or set a trial date. So at this point, we don't know when the trial date will be, but we do know that they have a date in November to set that date. So now I want to talk about Jennifer Crumbley's appeal. First of all, let's bring everybody up to speed on what the Crumbly case was all about. So the Crumbly case was a case where a mother and father were both charged and both convicted of negligent homicide because their adult son took a gun to his high school and pewed it up. Pew pew, right? So he was tried as an adult and actually he actually took a plea after it was determined. They had what they call a Miller hearing to determine whether or not he was competent to be tried as an adult. And the judge ruled that he was competent to be tried as an adult. And he then entered a plea, and he is serving a life without parole sentence. So it was very, very unusual for the district attorney to come out and say, we need to hold these parents responsible. It is very unusual, and you'll see why when we go through the appeal, because the state of the law does not lend itself to these sort of prosecutions. So, but this particular prosecutor said we need to send a message that parents need to secure their firearms. Now, what happened was, after the Crumbly case happened, the Michigan, I think it's Michigan where this case is, the Michigan legislature passed a lock up your guns law, which basically says you have a responsibility to secure your safe storage of your firearms. And if you don't safely lock up your firearms and they're used in the commission of a crime, you could be held liable, you could be criminally charged. But that law did not exist at the time that the Crumbly case happened. So we're going to talk today about appellate law and about the way that appeals work. And so in order to do that, I'm going to share my screen and I am going to attempt to read this off my screen while you all can see it. So there's first of all, I just want to sort of give you an overview of what an appeal looks like. So I've written a few appeals and this is what they look like. So the people of the state of Michigan versus Jennifer Crumbly. Defendant is the appellant and it's her brief on appeal. That's my cursor on here. You're not hallucinating. So the next thing is a table of contents, and that includes the index of all the authorities, meaning all of the statutes and all of the case law. The next thing is what questions are being presented in this appeal, and followed by a statement of why the court has jurisdiction and a statement of the facts. I'm not going to dwell too much on the facts because I think everybody has a pretty good idea. And we're going to go through each one of the questions as we go along. But as you can see here, there are many, many, many state and federal cases, and in some cases, and in some instances, cases from outside the jurisdiction that are being cited to as authority for their arguments. So there's other statutes, and then there's also some learned treatises. So those are usually in the form of professors who've written papers, articles in law review, and other law publications. These are the rules. These are the Michigan criminal rules. So one of the interesting things that we're going to find out is that that this is one of those places where civil law and criminal law sort of mesh a little bit. So we're going to talk a little bit about torts, which are legal wrongs for which you get civil damages, as well as the criminal provisions as we go along. So then they add a statement of the questions presented. Like I say, we're going to go over them individually within the body of the arguments, so we won't go over those. They allege that the court has jurisdiction to hear the case. Now they're laying out the facts of the case. On February 6th of 2024, a jury found Jennifer Crumbly guilty of 4 counts of involuntary manslaughter arising from the shooting committed by her son. He is referred to throughout this document as EC. It's kind of odd because he was a minor at the time of the incident, but he was tried as an adult. And I believe he has since turned 18. So his name is Ethan Crumbly, and he is referred to on and off here. So one of the first arguments is an argument um, that they made a post-trial motion for a judgment of acquittal or a new trial. So one of the reasons that they cited for that is that it came to light after the trial had concluded that the prosecutor had entered into a proffer agreement with two of the officials from the school. So we are going to have to talk a little bit about these facts. On the day of the shooting, that morning, Ethan went to school, and somebody within the school system, I'm not sure if it was a teacher or who it was, but discovered that he was drawing some troubling pictures of firearms, pictures of hurting people, and so they sent him to the school counselor, whose name was Sean Hopkins. So you'll see him referred to in this document. Then additionally, he was referred to Nicholas E. Jack, who was his who was the dean of students. So hopefully I've boosted the size here enough that y'all can see it. So um, so what happened was they agreed that they were not going to be held criminally liable if they came to court and testified against Ethan and against Jennifer Crumbley. So that morning, when Ethan was referred to the counselor and then to the dean of students, they called Jennifer Crumbley, and she went to the school. She and Ethan's father both went to the school. And they got there and they met with Ethan. They met with Sean Hopkins, the school counselor, and with Nicholas Ejak, the dean of students at the high school. And Sean Hopkins said Jennifer Crumbley offered to take Ethan out of school that day. And Sean Hopkins said, no, he's better off here than he would be home alone, because Jennifer was working. So we'd rather have him here than have him home alone. That's important. And we're going to get to that when we talk about some of the other arguments that this appeal makes. So it's important that they said, oh, no, he's probably better off being here. So the first complaint was that the defense did not know that those proffers had been made in order to get the testimony of those two people. So essentially, what they said was, as long as they came in return, this office will consider your client's proffer statements in deciding how to resolve the investigation as it relates to your client and any charges. So, in other words, come to court and testify, and we will not charge you. But they didn't tell the defense that they had those deals with those people. A lot of people wondered why the school officials were not being held responsible. This is the reason why. So they did not tell the defense that they had entered into those agreements. And that is clearly impeachment evidence. I mean, absolutely, the defense has the right to ask about those agreements and ask them about whether or not they made any agreements before they came to testify. So they claim that because of the deliberate suppression of the impeachment evidence, they were denied the opportunity to impeach these people about why they were coming in and testifying the way they were. So that was the first argument. Now, the second argument, I think, has a little bit less weight, but the prosecutor's office, right after the verdict, hired a public relations firm. Oh, no, within hours of the shooting, sorry. Within hours of the shooting, they hired public relations firms. And so and the prosecutor had granted exclusive behind the scenes access to a journalist from the Washington Post and a film producer for the purpose of making a documentary. They call it a sensationalized documentary because they're the defense. They're going to use those kinds of words to couch their argument in those terms. So they filed that motion with the trial court, and the trial court denied all of the post-trial issues, including a new trial because of the proffers and a new trial because of this sort of publicity charm offensive that the prosecutor was doing during the trial. So I just highlighted a few things. Counsel also learned after the filing of her post-trial motion that the producer of the documentary, who was granted exclusive behind-the-scenes access to the prosecution team, was related by marriage to the chief assistant county prosecutor. So there was some sort of a familial connection between one of the documentary producers and one of somebody in the prosecutor's office. I'm not really sure that that's going to carry the day, but I think there are some arguments that are going to carry the day. So the prosecutor's suppression of secret agreements with two key witnesses that amounted to a discovery violation because they were unable to cross-examine these witnesses on their proffers. I think, though, that may be very difficult for them to overcome, the prosecution to overcome. So the trial court just recently, in ruling on the motion for a new trial, the trial court issued its final opinion rejecting the remaining issue, which was the prosecution's suppression of the proffer agreements. This doesn't make a whole lot of sense. In its opinion, the trial court said the prosecution violated the rules of the criminal rules for suppressing an agreement to grant immunity, and the prosecutor violated another section of it. The court acknowledges that the defendant may have been hindered in presenting her defense because the opportunity to consider credibility is of paramount importance. So what the court says is the defense may have been hindered in presenting a full defense because they didn't get the opportunity to present any evidence about the witness's credibility. And impeachment of credibility is of paramount importance. The court also found that the prosecution's violations of the discovery rule were intentional. The violation was intentional. The prosecution could have and should have easily avoided a discovery violation. In spite of that, the the court concluded that the defense wasn't prejudiced by the prosecution's intentional multiple discovery violations and denied relief. So that's where we are at the trial court level. So now this brief is directed to the appellate court saying these are all the ways that the trial court messed up and that Mrs. Crumbly's rights were violated. So that is the first. Now we get into what I think is probably going to be the heart of the appellate argument. So in a most suits for negligence arise out of civil cases, out of tort law. When we get to the point where we're talking about reckless or negligent behavior, then we're starting to draw out of civil law some of the definitions that are usually used in civil court. So one of the things that has to happen in order for someone to be found to be negligent is that they have to owe a duty of care to the person who is negligently harmed. Okay? So their argument is that she is entitled to a judgment of acquittal because she didn't owe a legal duty to the victims of her son's criminal acts. And because she didn't owe them a duty, she can't be held criminally responsible for the involuntary manslaughter. So it's interesting here. Here's what they say. Here, the trial court rejected defendants' no duty argument and held that Michigan law imposes upon a parent a duty to exercise reasonable care so to control his minor children as to prevent them from intentionally harming others or from so conducting themselves as to create reasonable risk of bodily harm. That was the trial court's finding. The trial judge found that Ms. Crumbly had the duty of a parent. She found that Michigan law imposes the duty on a parent. But they actually appealed this prior to trial. There was an interlocutory appeal prior to her going to trial. And so the footnote says it should be noted that in its prior opinion in this case, the appellate panel did not address, discuss, or opine as to whether Ms. Crumbly owed a legal duty upon which to find her criminally responsible. Instead, the panel focused solely on the issue of proximate cause, as that was the issue raised by counsel in the motion to quash. So what they're trying to flag the appellate court to is saying, you might think that this issue's already been decided at the appellate level, but no, it hasn't. So let's talk a little bit about causation and duty, because that's really at the heart of this case. So in general, you cannot have a negligence claim unless the person has a duty to a duty of care, as the law says, to a particular person. So while there's no question that she had a duty to Ethan because she had a parent-child relationship with him, which the law generally looks at as a special relationship that gives rise to a duty of care. She did not have a duty to all the unknown students at the high school, but school officials did have a duty of care. So, the duty, which is derived from civil law, is a duty to protect a child from himself or his environment because of age. Think about a toddler wandering in a parking lot. So, a parent has a duty to keep their own child safe, and it's the parent's responsibility to make sure their toddler's not running around in the parking lot. It is not necessarily the duty of the parent to assure that their teenage child doesn't go out and hotwire a car and run down somebody in a parking lot. So there's a big difference. So that's where we get the definition for what a duty is, really comes from civil law. Negligence only attaches if this person had some sort of a duty of care to the person who was injured. The next thing that has to happen is that the person who has the duty had to also be the proximate cause of the injury. So in proximate cause, what we say is, in order for this person to be the proximate cause of the injury, that there has to be a sequence of events. The event has to have been foreseeable as a result of the defendant's negligence. There has to be a direct, unbroken chain of events from the defendant. Remember, we're talking about Jennifer Crumbley. So it had to be foreseeable that as a result of Jennifer Crumbley's negligence, those children in the high school would be injured. There has to be a direct, unbroken sequence of events. If there is an intervening event, then that sequence is broken. So one of the questions is whether or not the fact that the school was involved, does that break the chain of causation? We're going to talk a little bit more about that as we get through this brief. So essentially what proximate cause says is, without the defendant's actions, the injury wouldn't have happened. So in legal terms, how do we get from Jennifer Crumbley leaving the house that day and Ethan getting into the lockbox and taking the gun and taking it to school? How do we get to her to actions that cause the injury, so that we can say, except for her actions, the injury wouldn't have happened? Now, under Michigan's new safe gun law, I think there would be a potential to make the argument that there was a duty to lock up the gun under the law. There was an expectation under the law, and she didn't do it. But that law only came into being because of the Crumbly case. So at the time of the crime, there wasn't any legal duty to safely store firearms. Now, in her testimony at trial, she testified about the fact that the gun was in a lockbox, but Ethan knew where the key was. So, but remember, we're dealing with a 16-year-old or 17-year-old, 16, I think, 16-year-old boy, not a young child. He also was a 16-year-old boy who had been trained on how to use firearms. So, first of all, they're saying um, that she did not owe a duty to the students. Under common law, a charge of involuntary manslaughter based on an omission to perform a legal duty requires the following elements. First, that there was a legal duty. Second, that there was capacity, means, and ability to perform the duty, and that there was willful neglect or refusal to perform a legal duty. And then, fourth, it resulted in death as a direct and immediate consequence of the defendant's failure to act. So the question is, in the law, and where they're citing cases here, duty is essentially a question of whether the relationship between the actor and the injured person gives rise to any legal obligation on the actor's part for the benefit of the injured person. So, does Jennifer Crumbley have a legal duty, a legal obligation to unknown students at the high school, um, and that to their benefit? Does she have a duty to protect and a duty of care to those injured people? So they go on to say the prosecution's theory was based on the prosecution's theory of liability was based on two ideas: that she was grossly negligent in storing a firearm and its ammunition so that he had access to it, or in the alternative, that she was grossly negligent in failing to perform a legal duty, failure to exercise reasonable care to control her minor child, to prevent him from intentionally harming others. So they go through the argument that she didn't owe a legal duty to the victims of her son's criminal acts. They go on to talk about the difference between, and we're really getting into the weeds here, there are two different kinds of legal duty to base liability on. One is misfeasance and the other is nonfeasance. So misfeasance, the court has distinguished active misconduct from passive inaction or the failure to protect. So clearly in this case, they're alleging it wasn't misfeasance. She didn't do anything to directly cause the personal injury. So this is clearly a case of nonfeasance or failure to act. So they make the point, and this is one of the cases that they cite at length. There is no legal duty that obligates a person to aid or protect another. The only exception to that general rule is where a special relationship exists between persons. So a lot of those special relationships are the same sort of relationships that we talk about having um, having uh, being required to keep confidences or those sorts of things. So a priest and a penitent, a doctor and a patient, a mental health therapist and a patient, a parent and a child, those sorts of relationships. So the rationale underlying the general rule: absent a special relationship, a person has no legal duty to protect another from the criminal acts of a third party. And that's rooted in the fact that criminal activity, by its deviant nature, is normally unforeseeable. So we get back to the issue of proximate cause. Was it foreseeable as a result of the defendant's negligence that this outcome would happen? And one of the ideas that the is rooted in the law is that criminal activity is normally considered to be unforeseeable because criminal activity, as they say, by its deviant nature, criminal activity is not rational. Criminal activity usually involves an irrational act. And so what they're saying is you can't foresee an irrational act. So they go on to cite some additional cases, and they say the trial court agreed in principle with this proposition when it aptly noted the court recognizes that the defendant had no connection, control, or special relationship to the victims. Despite this recognition, the trial court went on to find there were special circumstances where defendant's own conduct increased the foreseeable risk of harm to the victims. And they believe, and I think rightly so, that that was wrongly decided by the trial court because the trial court recognized that she did not meet any of the usual descriptions that would give her a duty. In spite of that, the trial court said there were special circumstances. Well, there's nowhere in the law that talks about special circumstances. There's nowhere in the law that talks about in this special circumstance, the defendant has some sort of increased risk, increase the foreseeable risk, and that somehow that makes her culpable in this case. So I think this is really the heart of this argument. Now, they make this argument in a footnote, and we're going to get to this argument because I think that it's important. I think it's a good argument when we get a little further. Now, they say the same cannot be said as to the school officials who received proffer agreements by the prosecution. Unlike Ms. Crumbly, the victims of the shooting did in fact entrust their safety to the school, such that the school officials were in the best position to provide a place of safety. As such, the only duty imposing special relationship in this instance was between the school officials and the victims of the shooting. That further underscores the import of the proffer agreements that were suppressed by the prosecution. So what they're saying is, unlike Jennifer Crumbly, who did not owe a legal duty to the victims, the school officials did owe a duty. And we're going to see more about that as this goes on. So they go on to allege that she was under no legal duty to control and prevent her son from committing intentional criminal acts. They make the point here that the duty to control a minor child stems not from criminal law, but from civil law, civil cases involving claims of negligent parental supervision. And again, we get back to the issue. The case that they're talking about is a case where a toddler was allowed to run in a parking lot, and a car hit and killed the child in the parking lot. And they went after the driver, saying he had a duty of care and was negligent and hit the child. That their defense to that was, no, the driver of the car didn't have a duty of care or had a reduced duty of care when compared to the parents who should have been making sure that supervising their child and making sure that he was not running through a parking lot. So that's really a, a, a different story, because the parents had a special relationship and the parents had a special duty to their own child to protect their child from activities that would put the child at risk. That is not the same as a parent having a responsibility to anticipate that their 16-year-old son is going to commit a heinous crime. So, the parental duty, parents are expected to exercise reasonable care to control their minor child. Um, but they also say they are to provide instruction and education to ensure the child is aware of the dangers to his or her well being. This does not have anything to do with controlling a 16-year-old who goes out and commits a terrible crime. At the time, the next argument they make is that at the time of the shooting, Mrs. Crumbly was under no legal duty to safely store the firearm that her son accessed and used to commit murders. Now, this is where the court said that she had a legal duty, even though the safe firearms statute had not, the safe storage gun law didn't come into place until after this incident happened. So, but they oftentimes, when we enact legislation, we there are many hearings and legislative testimony and lots of things that go into passing legislation. And um, lawyers often look to that to explain the history of a law. And so we look to the legislative history, the testimony, the information that was presented to the legislature before they passed the bill. So what they say is, indeed, the legislative history makes clear that at the time of the shooting, prosecutors lacked the necessary tools to reliably convict an individual of an offense resulting from unsafe storage of firearms. So their own legislature recognized that the reason they felt they needed this law was because there was no mechanism for holding someone responsible for not safely storing a gun. So it says, despite the absence of any such law from which to impose a legal duty on Mrs. Crumbly, the prosecutor charged her anyway, notwithstanding that Mrs. Crumbly had not violated any statutes nor had she committed any crimes. The reason they say that is because she did not owe a duty of care to the students who were injured. The case law that does discuss a gun owner's obligation to keep a firearm out of the hand of a minor does so in the context of preventing accidental shootings by children, not of intentional criminal acts. So I thought this was important. To date, there are no appellate decisions in which a gun owner or parent was found to owe a duty to a third-party stranger where the minor child accessed and used the firearm intentionally to commit crimes. Such an absence of such cases is not surprising, since extending the negligent supervision duty of a parent over a minor to prevent intentional criminal acts would collide with decades of case law holding that a person has no legal duty to protect another from the criminal acts of a third party because criminal activity by its deviant nature, is unforeseeable. Foreseeable accidents are the concern underlying the negligent supervision duty of a parent, not intentional acts. So, what they're saying is that the whole reason, the whole concern underlying an accusation of negligent supervision of a minor isn't to keep somebody from committing an intentional act. It is to keep someone from foreseeable accidents. So, this next paragraph, I think, is also going to be really important, critical to all of this. And that is this: under Michigan law, when a child goes to school, the school assumes under the doctrine of in loco parentis, the school assumes the responsibility of a parent for the child. So let's say that again. In Michigan, under Michigan law, the school steps into the shoes of the parent and assumes parental authority as if they were the parent when the children are under their control and supervision. Because the school officials stood in the shoes of the Crumbleys under the doctrine known as in loco parentis, they, and not Miss Crumbly, were the ones who had a legal duty to the victims based on their special relationship. Okay? So, what is being argued is that even if you could argue that there was proximate cause, it was interrupted. Her duty was interrupted by the fact that Ethan was at school and the school was standing in the parents' shoes. So what they say here is the evidence at trial showed that Ms. Crumbly was summoned to the school by Sean Hopkins, he's the counselor, and Nicholas Ejak, he's the dean of students. They for a meeting during which Hopkins and Ejak expressly told Miss Crumbly that she did not have to take her son out of school. To the contrary, the decision was made by Hopkins and Ejak that Ms. Crumbly's son posed no danger or risk and that it would be better if he stayed in school around his peers rather than being home alone because Jennifer had to go back to work. She left work to go to this meeting. At the time of the shooting, Ms. Crumbly was not at the school and didn't exercise any control or supervision over Ethan's actions. So, in its instructions to the jury, the court made clear that Ms. Crumbly's duty was dependent on the jury finding both that A, she knew or had a reason to know that she had the ability to control her minor child, and B, that she knew the necessity and opportunity for exercising such control. Based on the record evidence, Ms. Crumbly could not, at the time of the shooting, exercise any control or supervision over her son. The school officials, on the other hand, did maintain custody control and supervision over the shooter. Under the doctrine of in loco parentis, it was Hopkins and Ejak, not Miss Crumbly, who were the individuals who had control and supervision over Miss Crumbly's son at the time of the shooting. And it was a joint decision that the shooter should stay at school with his peers, notwithstanding the events that led up to them calling them into that meeting. So their argument is that Jennifer Crumbly's duty ceased when she entrusted her son to the supervision of the school. Now, as we go through here, I have been skipping quite a few of the case citations where they cite to a case that stands for that rule. Other jurisdictions have applied this framework in finding a parent cannot be liable for the tortious or criminal acts of a minor son. So now, typically what happens is the appellate attorneys are going to cite first to Michigan Supreme Court and appellate law. They're going to cite to Michigan court decisions. The next thing they're going to do is sort of in order of importance as to what's more binding on this appellate court. First would be Michigan law, second would be federal law, and then third would be law from other jurisdictions. So now they're going to talk about law in other jurisdictions. Now, sometimes what happens is if it's a jurisdiction that's in the same federal circuit, and this may become a federal issue because there is a federal question, which this may very well happen. If there are jurisdictions that are within the same federal circuit, then generally they're a little bit more persuasive than a case that's completely out of circuit, as this is, because they're citing to a California case that stands for the proposition that absent a special relationship, an individual owes no legal duty to control the conduct of another person, and that the defendant mother in the California case had no effective control of her minor son at the time of the shooting. So this was a similar case out of California where the California courts found that the parents could not be held liable for the criminal actions of their son. And that court ruled that the absence of such ability is fatal to a claim of legal responsibility. So according to the California court, the key question asks whether the parents had notice of her son's propensity to commit violent crimes, and if so, whether the parent had physical custody, control, and the immediate authority over her son at the time of the criminal act. So Jennifer Crumbley's argument is that she did not have notice of her son's propensity to commit violent crimes. Even had not ever committed, it didn't have a history of any kind of violence. He hadn't been violent to animals. He hadn't been in fights. There was no history of that. That coupled with the fact that when she went to school that day, the school officials, knowing that he was drawing things that were alarming, said, no, we think he's fine. He can stay in school and that it would be better for him. So first of all, did she know that he had a propensity to commit violent crimes? The argument there is no, she did not. And if so, did she have physical custody, control, and the immediate authority over her son at the time of the criminal act? Clearly, she did not. He was under the physical custody, control, and immediate authority of the school officials. So I think that's a pretty persuasive argument. That Jennifer Crumbley didn't owe a duty to the unknown students who were Ethan Crumbley's victims. So, and the brief goes on to say, and while the prosecution makes much ado of Evan Crumbley's drawings from the meeting from the morning of the shooting, it should be noted that Hopkins, who admitted that he was trained to identify risks, testified that if he had believed that the drawing evidenced a plan to hurt people, he would have taken different actions. So that in itself you have to ask, well, then was that the proximate cause? Did he owe a duty to the students? Clearly, he owed a duty to the students. He was a school official that legally was in loco parentis. So there's no question that Hopkins owed a duty of care to the other students, the students who were killed and injured. But he admitted that he'd been trained to identify those risks and said he would not have allowed Ethan to stay, or he would have taken different actions if he'd thought the drawing was evidenced a plan. But obviously he didn't. So what the defense says is that at best, the prosecution's proofs show that Ms. Crumbley perhaps could have, in hindsight, taken additional or different steps regarding her son, but to suggest she knew of or should have known of his violent propensities to commit premeditated murder is simply not borne out by the record evidence. And they go on to talk about the fact that Mrs. Crumbley's convictions, that the prosecution cannot demonstrate the requisite causation to support such charges. So we talked about proximate cause. So now we're going to talk about what it means for there to be proximate cause. So first of all, in order for there to be proximate cause, the harm has to be foreseeable as a result of the defendant's negligence. That's the first key. Whatever harm occurred, in this case, the shootings, had to be foreseeable as a result of Jennifer Crumbley's negligence. There had to be a direct, unbroken chain of events from the defendant's actions to the student's injuries, a direct sequence of events. There couldn't be a break in that chain of events. It has to be an unbroken chain of events. Now, typically in a civil case, what they'll say is, we've heard things about how they can parse negligence and they can say, okay, you're 20% responsible and you're 80% responsible. And then that's how they'll figure out damages. That's not the way it works in criminal cases. So this footnote is really interesting. The Graves case, popularly known as the Jenny Jones case, this case is a good parallel to this case, and it did come from Michigan. The Jenny Jones case involved claims by a decedent's estate against the nationally televised Jenny Jones show. The plaintiff's decedent was shot and killed by a friend after the two appeared on the Jenny Jones show, at which time the decedent revealed he had a secret same-sex crush on his friend. The friend later shot and killed him. The Graves case draws some similarities to this case, insofar as the Oakland County Circuit Court allowed the plaintiff's wrongful death claims against the Jenny Jones show to proceed to trial, resulting in more than $20 million jury verdict. So in the Jenny Jones trial, which was a civil trial, the judge allowed it to go forward and they ended up with a $20 million award. The verdict was later thrown out by the Court of Appeals based on its holding that the Jenny Jones defendants owned no legal cognizable duty to protect the victim from the homicidal acts of a third party. That is a really persuasive holding. They owed no legal cognizable duty, I always have trouble with that word, to protect the victim from the homicidal acts of a third party, and that is a Michigan law. The Graves holding applies here with equal force, they say. So that's a really important case because it's almost, I mean, it's a very much on point, almost a parallel of this case in terms of who has an obligation to protect a third party from, to protect someone from the homicidal acts of a third party. Now, what the prosecution argued was that because Jennifer Crumbley was Ethan Crumbley's parent, that they had a special relationship that gave her an increased duty. We've talked about that, and I they distinguished that by saying that that was really not what the underlying cases found. The underlying cases found that they applied to parents protecting their children from dangerous situations and accidents, not to protect third parties from the criminal activity, intentional criminal activity of their offspring. So the next thing is the Supreme Court of Michigan's holding in People versus Marshall forecloses the state's ability to prosecute both the Crumbleys for involuntary manslaughter. So they talk about involuntary manslaughter is a common law crime that Michigan has codified. And in Michigan, it's defined as the killing of another without malice and unintentionally, but in doing some unlawful act not amounting to a felony, nor naturally tending to cause death or great bodily harm, or in negligently doing some lawful act in itself, or by the negligent omission to perform a legal duty. So what they're saying is that in order for there to be involuntary manslaughter, you have to cause the death by doing some act that naturally tends to cause death or great bodily harm, or to negligently do a lawful act, or by the negligent omission to perform a legal duty. So you either have to fail to perform a legal duty, you have to commit an unlawful act that's dangerous, or you have to negligently do some lawful act. So then they go to the People versus Marshall. The legal theory. Now, this is a 1961 case, so this is well-settled law in Michigan. The legal theory of which is remarkably similar to Ms. Crumbly's prosecution. Marshall involved charges against the owner of an automobile who had given the keys to Neil McClary, knowing that McClary was drunk. McClary then drove Marshall's car the wrong direction on an expressway and crashed head-on into another car, killing both himself and the other driver. Marshall, who was the owner of the car, was then charged and found guilty of involuntary manslaughter. But at the time that the accident took place, Marshall was in bed. He was not in the car. And his only connection with the accident was that he owned the car, just like Jennifer Crumbley was at work. Ultimately, the Supreme Court determined that Marshall, as a matter of law, was not guilty of involuntary manslaughter. The state, so they go through the specifics of the case because it is so analogous to the Crumbly case. So the guy was the owner. The owner said the court sat. There was an earlier case. The state was relying on an earlier case in which the owner of the car was in the car with the drunk and let him take the wheel. And the court distinguished that by saying that the owner of this car owner was in bed, and he wasn't involved in any way in the misconduct. In the case before us, death resulted from the misconduct of the driver. So this would be if we were applying this, we would say in the case before us, death resulted from the misconduct of the shooter. The accountability of the owner must rest as a matter of general principle upon his complicity in the misconduct. In turning his keys over, he was guilty of a specific offense for which he incurred a specific penalty. Upon these facts, he cannot be held a principal with respect to the fatal accident. The killing of Cold Iron was not counseled by him, accomplished by another acting jointly with him, nor did it occur in the attempted presence of some common enterprise. So essentially, the court is saying on these facts, this guy's home in bed. He didn't tell the guy to take the car. He wasn't a joint actor, and it didn't happen in the presence of doing a common enterprise. So the brief goes on in this case to say, yet the Marshall Court found these facts insufficient to find one guilty of involuntary manslaughter. Instead, the Marshall Court required the state to demonstrate either physical presence, counseling in the killing, or joint action, or a common enterprise. So now they're going to apply those rules that came out of the Marshall case to the Crumbly case. Here, there are no facts to support that Ms. Crumbly's convictions under any of these four factors. She didn't counsel Ethan in the commission of the school shooting or act jointly with him in any way. To the contrary, she had no knowledge that her son intended to commit multiple homicides, nor did any common enterprise exist, nor was Miss Crumbly present at the time of her son's criminal acts. So typically, this same analysis would be applied to accomplice liability in a civil case. Okay, we're not talking about accomplice liability in a criminal way. We're not talking about it as defined in the criminal law. So the physical presence of the defendant and his direction to point the gun at another, this is a separate case. As evidenced by the limited cases interpreting Marshall, the legal standard pronounced has typically been supported in analysis pertinent to accomplice liability and proximate causation. In this People versus Turner case, they talk about the fact that it's distinguished by the fact that in the Turner case, the defendant was physically present, and it was at his direction that the gun was pointed at another. And that was enough to establish liability as an accomplice to involuntary manslaughter. But that's not anywhere near what we have in the Crumbly case. So, so now we need to talk about, again, proximate cause. Now, remember, these are legal arguments, and you can start saying, okay, lawyers will argue about how many angels can fit on the head of a pin. And that's true, we will. And I say 5. But these legal arguments are really the heart of an appeal. So when you are in the trial court, the arguments are about the facts. You want to talk about what happened, who did what, what kind of evidence was found where, all of those things that come into play. Those are heard at the trial court. At the appellate court, they're arguing the law, and that means that we are arguing about angels on the head of a pin. So now what they're saying is that even if the prosecution could demonstrate that Jennifer Crumbley was proximately the cause of these intentional criminal acts of her son, his intervening actions supersede that cause. So what we say is proximate cause has to be an unbroken chain of events. What they're saying is that even if you could find that there was a duty and that Jennifer's lack of care was a proximate cause of the murdered student's injuries, Ethan Crumbley's discrete actions were an intervening or superseding cause, and so she can't be responsible because something else, bolt of lightning from the sky, whatever, some other event stopped her duty and started Ethan Crumbley's duty. So they go on to talk about factual causation versus proximate causation. So they talk about factual causation exists if a finder of fact determines that but for a defendant's conduct, the result would not have occurred. But a finding of factual causation alone is not sufficient to hold an individual criminally responsible. Hear that? A finding of factual causation alone is not sufficient to hold an individual criminally responsible. The prosecution must also establish that the defendant's conduct was a proximate cause of the victim's death. Proximate causation is a legal construct designed to prevent criminal liability from attaching when the result of the defendant's conduct is viewed as too remote or too unnatural. So, if the finder of fact determines that there was an intervening cause that supersedes a defendant's conduct, the causal link will be broken between the defendant and the victim. Hopefully that makes some sense. I think this is a really good argument, and I think these are important things that the appellate court needs to consider. So we're almost to the end of this, and I'm not going to go through any more of the arguments because I'm sure that you probably have had your eyes are glazing over. But I think that they make some really interesting arguments. First of all, they argue that Jennifer Crumbley didn't have a duty of care to the students, that in fact, the school officials had a duty of care to the students, and that they were relieved of any criminal consequences by their proffers, proffers that were kept from the defense so that they couldn't be used as impeachment material at Jennifer Crumbley's trial. They also argue that even if you were to find that Jennifer Crumbley owed a duty to the students, that Ethan Crumbley's activities and his decisions superseded that duty. So these are all really, really interesting arguments, and I want to thank Jabberday for bringing them to our attention. I've droned on way long enough, and I'm sure that you all would probably like to throw some questions in the chat. So while Jennifer is looking for some questions, I will uh, I will sort of wrap up. There's no quiz on this. Believe me, it takes 3 years of law school to even get to the point where you sort of begin to understand the way that appeals courts think as opposed to trial courts, and the way that these decisions stack on top of one another. So, for those of you who are really interested in the legal process, that may have been really interesting. For those of you who are like, "Oh, no thanks, I just want all the juice," it might have been a little tedious, and I apologize for that in advance if it was. I have been trying to take the opportunity to do a bit of a deep dive into some of these legal issues during this time when we don't have a lot of high profile sorts of cases to talk about. So, if you have a case that you would like me to take a look at, please drop it in the chat, drop me a message, and let me know, because I am interested to look into anything that you're interested in. Also, if there are legal questions, if you want me to talk about bail, or you want me to talk about extradition, or you want me to talk about uh, probable cause or discovery or any of those things that are part of the process, I'm happy to do that, because I think, I think need we need to understand. Do we need to understand all the nuances of proximate cause? No, that's my job. But I think it helps for us to understand how the appellate court is going to look at this. When, oftentimes what we hear is, oh, I mean, for example, in Delphi, Richard Allen got convicted. Oh, well, there's always an appeal. Well, what does an appeal really look like? Does the appellate do the appellate judges get to look at the evidence? No. They get to look at whether or not the trial judge made a mistake in the way that they ruled at the trial level. So in Delphi, they're going to be asking questions like, did Judge Gull make a mistake when she didn't allow the third party culprit? Is the appeals court going to decide whether or not um, a third party culprit could be responsible based on the facts and the evidence? No. They are going to decide whether or not Judge Gull abused her discretion when she decided not to allow that to come in. So you can see that it is a much harder, more difficult uphill battle to get um, an appeal, to get a case overturned on appeal, because most courts are going to say, we're going to defer to the trial court level, who was there and who heard all the arguments and saw the people and got to judge their credibility, and we're going to defer to that. And that makes appeals more difficult. I think sometimes we sort of flippantly think, oh, well, there's always an appeal. But we don't realize what a true uphill battle that is. Only a very small percentage, first of all, only a very small percentage of cases are argued in front of the state Supreme Court. Many of those cases, now, at the state Supreme Court level, they can't deny to hear them. But what they can say is, we're affirming the lower court's decision without writing an opinion. And so in in Oregon, we get a lot of what we call LWOPs, affirmed without decision. And so we get a lot of those sorts of decisions. I mean, here's a for instance. When I was still practicing, I got a phone call from our chief judge uh, through our appointment process, right? And the judge said, I'm assigning you this case. It is a ballot measure 11 case, which means that it carried, it was a violent crime, and it carried a mandatory sentence. Like a lot of states, Oregon has a sentencing matrix that requires, not allows, requires a judge to impose a specific sentence for a specific crime. If the person is found guilty of the crime, this is the sentence. They don't get good time. They don't get eligibility for any kind of programs. They serve their time day for day. And and it applies mostly to very serious crimes. So I get assigned to this guy. And part of the problem is he was in custody. And so he was demanding that he get a speedy trial. He was kind of playing the chicken game that Lori Vallow played. I want my speedy trial. So the judge said, okay, you're not going to waive your right to a speedy trial. You've already said several times you're not going to waive your right to a speedy trial. But the guy kept firing his public defender. So I was actually the third lawyer on the case. So I came into court that day to pick up the appointment. The guy's there in handcuffs, and he sits down next to me, and the judge looks at him and he says, "This is your new lawyer. Your trial starts in 9 days." What? 9 days? Ballot measure 11, serious crime. It was an armed robbery. We're talking about 9 months to get ready for one of those. 9 days? And the judge looked at him and he said, "You have asked for 2 lawyers and dismissed 2 lawyers. This is your third lawyer. You're just doing this to try and draw this out because you think that if you don't get to trial by your trial date, I have to release you. So I'm telling you, be careful what you wish for, because your case is going to trial in 9 days." And he looked at me and he said, "Miss Hellis, I expect that you will do your best to prepare for this trial in 9 days." And I said, "I'll do my best, but I can't make any guarantees." I mean, I couldn't even do any investigation. Fortunately, I had a little investigation from the prior attorney, but holy cow, it was crazy. But so here's the next thing that happens. The next thing that happens is the guy gets convicted. We have a jury trial. The jury finds him guilty. He gets convicted. Now, the judge doesn't have any discretion in what he's sentenced to. If you're convicted of this crime, you get this sentence. So he gets like an 8-year prison sentence. He very promptly appeals. He appeals on the basis of ineffective assistance of counsel, rightly so, and he appeals on the basis of that he was pressured to trial because of his speedy trial rights. Well, I can tell you that he immediately said, "I want to appeal." I immediately referred the case. There's an online filing that you do saying, "I was the trial lawyer, my client wants to appeal," and it goes to the appellate counsel. There's an appellate division at the public defender's office. So it gets referred to the appellate division. The appellate lawyer calls me and says, "Are there any issues?" And I said, "Well, none that I know of, other than the fact that I had to take this case to trial in 9 days." He says, "Okay." So they file the appeal, and the appeals court promptly which is really surprising because sometimes it takes 2 or 3 years before the appeals court rules, but this was less than a year. The appeals court affirms without any opinion. He then appeals to the Oregon Supreme Court, and the Oregon Supreme Court once again summarily says we're upholding the lower court's decisions without writing any kind of an opinion. That is very typical of what happens at the appellate level. Now, it's not going to happen in a case where there are valid arguments about errors at the trial court level. So, for example, in the Crumbly case, where they're making some valid arguments that the prosecution was really outside the scope of the law, and that Jennifer Crumbly cannot be convicted because she didn't owe a duty of care to the students who were murdered, to the victims. So I think those are sort of important things to understand about how the system works so that we're not just flippantly saying, oh, well, they can appeal, because appeals are complicated. And there is, I would say, less than 1% of cases get overturned on appeal. And probably less than 10% of the cases even get argued in front of a panel. An awful lot of them are just the lower court rulings are affirmed. So it's hard to get an appeal. Now, I think Jennifer Crumbly's going to get, her lawyers are going to get an argument in front of the full appeals panel. And the prosecution will have the next step is the prosecution will file their reply brief. There might be a couple of might be a SIR reply brief. But at some point they will schedule oral arguments, and the court will issue a decision, because these are weighty questions that I think need to be decided by the appellate court. So, let me know if this stuff is interesting to you and and you enjoyed it. If it was dry and boring, let me know that too, because it helps me decide what to cover and what to do as we go forward. So trying to kind of fill in the blanks as we don't have a lot of cases to talk about right now. So I did want to kind of look over the schedule of the next few months and talk about what's coming up. October is kind of a dry spell. We do have, in fact, the one thing I had on there has been moved. So we don't have anything for October. Same for November. I have a blank page for November. Now, those things could always change. We do know that we have a couple of things coming up we talked about earlier. We have Barry Morphew's status coming up in November. Rawl Valley's got an appearance on the 15th of October. And then the Shanna Cloud Clint Bonnell case has a hearing coming up on the 13th of November. So we do have some things that are starting to pop up in November. Now, in December, we are going to be off. Jennifer Gledhill's trial is coming up in December, although that may move. And Lindsay Clancy has a pretrial conference coming up on the 1st. And then in January, we have Lindsay Clancy, we have Larry Millette, we have Corey Richens' pretrial on motions, all of her pretrial motions. We have Tracy Grist and Kevin Ellis in Utah in the Restelli case, Dee Warner, and also Tressa and Brittany Collins in the murder of Shannon Collins. And those are primarily felony fraud cases. So we are going to be offline in December, as I told you. I'm going to have my knee replaced in early December. So between that and the holidays, we're going to take the month of December off. Um, Everybody, keep your fingers crossed. Send me good juju or prayers, whatever you feel like, because my book proposal for my new project is going out to publishers on Tuesday. It's in the hands of my agent and is going out to publishers. So keep that in your thoughts. And I hope that it won't be too long before I will be able to let everybody know um, what the project is and how we go forward. So, what you got for me, Jennifer? Tiff. Hi, Tiff. If your 15-year-old child deals drugs at school and some kid overdoses on the drugs he sold, are the parents liable for the death? Well, I think this is a really good parallel. Um, l- but but let's make the parallel even tighter with the Crumbleys. Say you have a 15-year-old child and you have a family member who has had a serious medical condition or has had a surgery, and there are floating around in your house some opiates, and your kid goes through the medicine cabinet, which is not secured because they're 15, they're not 3, and finds these opiates, and the kid takes them to school, and one of the kids he sells them to has an overdose and dies. Now we have something that's very parallel to the Crumbleys. Something in the house wasn't secured, taken to school by a 15 or 16-year-old, and it results in the death of another student. Do those parents, is it negligent manslaughter on the part of the parents because they had a duty to control their child and secure the medication? I think that's a parallel argument. And I think that the case law, um, in at least in Michigan, is pretty clear that the parents do not have a duty to that student who has died, that the intervening illegal activity of the child um, it intervenes and overrides or supersedes the proximate cause. So good question, and I think that's the answer. But guns are a hot button, and so we'll see what the Michigan Supreme Court, the Michigan Appeals Court to begin with, does with it. So good questions. Don Shackelford, I see that you are in the chat. Thank you for the package you sent me. I'm excited for it. We don't make a lot of political statements on this channel, but she sent me some fun political t-shirts. So, so thank you, Don. What else have we got, Jen? Hi, Carol. Did the law enforcement prosecutor ever ask her why she didn't remove the gun after seeing the pictures he drew? Well, I don't know that they did. First of all, the prosecutor doesn't probably want to know. I don't think they did. And what I'll say is um, she left the school. She, first of all, she wouldn't have been able to remove the gun after seeing the pictures. She was called from work to go to school and meet with the dean of students and the counselor to talk about the picture Ethan drew in school. She then was assured that he was better off being there than he was um, at home alone, and she then went back to work. the gun was already in Ethan's backpack. So if she had gone home to secure the gun, it wouldn't have been there because he already had it with him. So I think it was a real failing on the part of the school not to ask to see the contents of his backpack. What else have we got? Oh, sorry, Dawn. Wrong Dawn. I'm seeing a note that says, me? I think you're confused. So sorry. Hi, Beth. What about the duty of the school counselor? You know, the one with the education who gets paid for monitoring kids while they're at school. Yeah, well, this is one of their arguments. One of their arguments is that under Michigan law, the doctrine of in loco parentis applies, meaning that the school officials step into the shoes of the parents and are responsible for custody, care, control, all of those things that parents would be responsible for. So I think this was a very clear, um, a very clear end run around holding the school officials responsible, and in that regard, that's pretty reprehensible. The two school officials, they had the obligation and the training, and yet that school counselor said, "Oh, I don't think based on his drawing that he's a danger," or I would have done I would have done something differently. So yeah, I think that the prosecutor made a huge mistake in essentially giving them immunity in return for their testimony against Jennifer Crumbly. They made proffers and the prosecution agreed not to prosecute them. Seba? Well, I had a cat named Seba. Are you named after my cat? The funny story. I had a really good friend, lawyer friend, who was a practicing Buddhist. And one of the things that she was doing in her practice was she was helping animals. And so she rescued cats, and she was very involved with an organization that trapped feral cats and spayed and neutered them to keep the feral colonies down. And so one afternoon she called me and she said, "I have a kitten for you." And I said, "Ugh, I don't need a kitten. I've already got at that point 3 cats." She said, "No, no, no, this cat's got blue eyes." So she knows I'm a sucker for a cat with blue eyes, right? Siamese are my jam. And I say, "No, I don't need a cat." Well, then I get home and we had just gotten our first dog ever. And he was a puppy. He was about 5 months old. And the breeder where we had gotten them, he had been kind of the lone puppy for a while. And so that we took him, and he had been alone and living sort of as a pet in their house. And he was very, very friendly with their cats, who were very used to dogs and were quite playful and friendly with dogs. So he gets to my house, and I have these 2 old bitty Siamese. I mean, they are old and crouchety and set in their ways. They want nothing to do with a puppy. The puppy comes in and they look at me like, "I don't know what that is, but play with it outside." So my husband says, "Well, the dog really seems heartbroken that the cats don't want anything to do with him. Maybe we need to get him a kitten." So I troop over to this friend's house and I bring home this 5-week-old feral kitten. She was an orphan. I mean, we're feeding her with a bottle. And so in honor of my friend, I try and figure out a nice name for this cat. So I do some research and I discover that Siba, spelled just that way, um, in in Tibetan, I think, means dear to hold. So we decide that we're going to name this cat Siba. Well, never was a cat less appropriately named than that cat. She was absolutely independent, wanted nothing to do with anybody, didn't want to be picked up, didn't want to be bothered with people, and uh, but was also a feral kitten. So at a very early age, was already very concerned about where her next meal was coming from. So she grew up to be a very big old lady who we lost a little bit earlier this year at age 16. So she had a great run, but she was Siba, um, very not so much dear to hold. So, okay, now to your question. But when the shooting was announced, she immediately thought her son did it. You know, what parent wouldn't? You get called to your kid's school just a couple of hours earlier where people are concerned uh, about a drawing that he's made that talks about violence and talks about guns. And you're assured, no, it's okay. We don't think he's a threat. We're going to hang on to him. He's better off here with his peers being supervised than he is at home alone. And you go back to work. You've received assurances from the school, but I'm sure that that didn't relieve concerns for her. She was talking at that point about getting him into mental health treatment, and part of what she went back to her office to do was start making some phone calls to get him into some immediately get him into some therapy, because that's what the school officials said was sufficient. Remember that. At no point did the school counselor or the dean of students say, this kid is a danger to himself and others. He immediately needs to go to the emergency room. He immediately needs to be evaluated, and he needs to be on a 72-hour hold. They didn't do any of that. They basically said, well, it's not that bad and he can stay. So, of course, what parent wouldn't, when just a few hours earlier, your son who goes to that school and has already been counseled, you've already been called in because of these violent drawings, of course you're going to jump to that conclusion. I would have. Um, I mean, I don't know how you couldn't at that point think, oh my God. I mean, that's where your brain is going to go. There's a really good but extremely graphic um, series on HBO, and it's called The Pit. And it's a fascinating medical drama where every episode is an hour in in an emergency room in um, in Pittsburgh, and it's excellent. But they cover a lot of social issues. And early in one of the earliest episodes, because it covers one 12-hour shift, it's 12 each episode is an hour of one 12-hour day. So earlier in the day, a mom comes in and she's very concerned about her son. He's very depressed. His father's just died. He's very withdrawn. She's worried about him. Later in the day, there is a mass shooting at a concert. And everybody, the mom, the medical staff, everybody jumps to the conclusion that her son is responsible. I think that is a natural reaction. And I mean, if you look at the sequence of events, she gets called in because your son's got these violent drawings that everyone is concerned about, and a few hours later, there's a mass shooting at his high school. What's she gonna think? So, that isn't a surprise at all to me. But, um, y y you know, in hindsight, we're all looking for I don't know whether we're looking for someone to blame. We're certainly not getting to the heart of what the problem is. How many mass shootings have we had this year? Hundreds, hundreds of mass shootings. We had one just this last week where a guy went in and shot up a an LDS ward uh, on Sunday and then set the church on fire. I mean, these things are happening all the time. We as a society need to figure out how to address those issues. I don't want to get into a lengthy discussion on the Second Amendment, but what I do want to say is we need to figure this out. We need our kids not to be practicing lockdown drills more than they're practicing their multiplication tables. We need to figure this out. Um, and we need to assume at this point, based on the track record, that our political leaders do not have the will to solve it without us. So we need to figure it out. So, last questions? Seba is the first initials of my children's names. Isn't that funny? Well, Seba was my cat. And the first initials of your children's name mean dear to hold in Tibetan. So there. When is Shanna Gardner coming up? You know, her trial was moved. It was supposed to be coming up this month, and it was postponed, and it went out a long way. So let me look here. Lindsay Shivers, March. Um, you know, I don't see it on my list here, but I know it got set out. So let me just keep looking here for a minute. I'm actually not sure that a new trial date has been set. We have Corey Richens coming up in February, but hang on and let me just do a little Dr. Google here and see if I can find out. Let me see if we get anything. Oh, August of 2026 is when it is now. I knew it had been pushed out. Oh, so that's the reason why I don't have 2026 out here yet. I'm not that far out. So August of 2026. Oh, there she is. Found her. So, yeah, I knew it had been set way out. So, all right, let me get rid of that. Stacy, are you following the Sarah Hartsville case? Multiple ex-husbands died, but all ruled accidental until this one. I'm wondering if they can bring in previous cases that have been reopened. Sure. I mean, we saw that in Peterson, not Lacey. He was an ex-cop. I want to say, in Colorado or Utah again. Come on, you guys help me out here. Anyway, his first wife had died under suspicious circumstances, initially been ruled a suicide, and they reopened her case because they felt that he was responsible. And then he got he was charged with that one, and then what Drew Peterson, right? And thank you, Liz. And they use that um, as a aggravator in the case where he had murdered wife number 2. So yeah, it's been done before, and it can be done if. And I did hear about that case. I think this is husband number 5. And out of them, sounds kind of like Lori Vallow. Out of them, I think only one is still alive. Not sure. So that is an interesting case. And yes, they can go back and take a look at the circumstances of the deaths of his earlier spouses. And there's no statute of limitations on murders, so they could go back and prosecute him. That's what they did with Drew Peterson. So, good questions. And thank you, Liz. Yes, August 3rd of 2026 is Shanna Gardner. It keeps getting bumped out. Oh, and Drew Peterson was Illinois. Well, let's take one last question since we're about 5 minutes over the 2-hour mark, and I like to stick to that 2-hour mark. So let's take one more question. Anybody's got one? In the meantime, I'd like to thank you all for being here. Thanks for spending your Wednesday with me. Thanks for letting me make your eyes glaze over talking about appellate law. Hopefully that was um, informational, informative for you all. And and thanks again for joining us. Thank you, Liz. But did she ever take to the dog? Oh no, poor Seba. Actually, Seba did take to the dog. My pet got a pet, and they were famous fast friends. I think she liked the dog more than she liked anybody else in the house, frankly. And as a little kitten, he would carry her around in his mouth, and he was a Labradoodle puppy. So he was going to be a big dog. He eventually got to be 90 pounds. So, yeah, she was a tiny little 5-week-old kitten. He would carry her around in his mouth. So they were good friends. She did warm up to like the dog, and the 2 old Siamese, now they never warmed up to the dog. So they kind of they kind of agreed just to pretend the other one wasn't there. So it was sort of a demilitarized zone in the house, but they never really warmed up to each other. But Seba did. Yeah, she was his kitten. So that's what happens when you are a household that has pets. So right now we have 2 Siamese cats and 3 dogs, 2 Labradoodles and 1 little guy who's a Chihuahua mix that is my mom's dog, and he lives with us. So yeah, we're a pet loving family. Well, y'all, I'm going to say goodnight. Thank you for joining us. Please let me know if you'd like more or less content having to do with more like legal deep dives, whether that's interesting or whether it was boring. You let me know. Thanks for being with us tonight. Have a great week, and I will see you next Wednesday for more True Crime Wednesday. Good night.